Hi everyone. I am sad to say that you are viewing take 2 of my attempt at recording a lecture for tonight. The positive side of this is that you will probably get a much shorter lecture than the initial one that I had recorded. So we're going to pick up with our assignment 13 discussion of advanced warranty disclaimers. And as a bridge between the content from Tuesday and the content for today, let's take a look at our golf course problem. And I think that a lot of you did a really nice job analyzing this. A few of you were maybe overly optimistic or overly litigious, depending on your point of view. So one of the things that I pointed out in the call of the question itself, and you'll certainly want to be thinking about, especially I think you'll be thinking about it as we finish our discussion of assignment 13, is this question of consumer versus commercial parties. The question about the golf course establishes quite clearly that we're dealing with a commercial party. And so Magnus and Moss claims aren't going to be an issue. Right? Then, as always with warranties, you'll want to be thinking about what is the warranty that you would be bringing a claim under in this situation. And there's nothing about the call of the question that suggests that express warranties were given or that there was some sort of exchange that would lead to an implied warranty of fitness for a particular purpose. So if the purchaser here, Queen Bee, is going to be alleging some sort of product defect with the goods, it's going to be under a theory of implied warranty of merchantability. Okay, so now we look at the language of the disclaimer itself. And the language of the disclaimer itself meets the requirements that we see under 2316 in terms of conspicuousness and in terms of using the requisite wording around merchantability, implied warranty of fitness for a particular purpose. Again, because they're disclaiming implied warranty of fitness, that's in writing, it's conspicuous, as is the exclusion of the implied warranty of merchantability. Now, some of you did take a little bit of time to think about the fact that it does seem as though the language of this clause is serving to limit the remedies and to exclude consequential damages, because it says the exclusive remedy of buyer and the limit of liability for any and all losses, injuries, or damages resulting from the use and handling of this product shall be refunded of the purchase price. And so it's possible you could try to make a claim here that that language in its effect excludes consequential damages. And because it's not specific, it doesn't have a carve out, for instance, for personal injury damages, that this is somehow overbroad and perhaps by its wording prima facie unconscionable. I think it's a tough argument to make, given that we're dealing with a situation where the only alleged consequential damages are $34,000 in business losses for having to delay the opening of the golf course. But it's an argument worth thinking about nonetheless. Right, then I want us to go briefly through our swing set warranty that we see on page 248 of the textbook, Start of Assignment 13. And for those of you who read through Assignment 13 reasonably recently, this will seem like review, right? So let's look at the provisions in here that are related to, for instance, the Magnus and Moss Warranty Act. And probably the most important one that we see here that has Magnus and Moss implications is the fact that it is conspicuously labeled at the very top as a full 90-day warranty. So I've included a link on Twin in the web link section to an FTC website where they explain Magnuson Moss. You'll recall that the FTC is the federal agency tasked with administering Magnuson Moss. And I think this website's really nice in giving a reasonably sophisticated but also in some ways more approachable read on what does it mean for something to be a full versus a limited warranty. So you should recall Magnuson Moss requires every written warranty on a consumer product that costs more than $10 to have a title that says the warranty is either full or limited. And the Act calls these designations, right? Either full or limited. And this full or limited designation is meant to give consumers some guidance as to what they might expect to receive under the warranty. So what does Magnuson Moss require in a full warranty? Right. So if you are giving a full warranty, each of the following has to be true about the warranty, right? To label it full under 2304 of Magnuson Moss. Right. So first of all, you do not limit the duration of implied warranties, right? Which essentially means the implied warranties remain. You're not supposed to limit their duration. In other words, they can't be disclaimed. Right? You provide warranty service, this is point 2, you provide warranty service to anyone who owns the product during the warranty period. And they point to the definition of a consumer. So you'll recall we talked about how Magnuson Moss might help do away with certain issues around privity, although we discussed that it seems to say you actually need to transfer ownership of the product. But importantly, it doesn't just flow to the initial purchaser, it flows to the warranty benefits, flow to anybody who owns it during the warranty period. Point 3, you provide warranty service free of charge, right? So if you're giving a repair, for instance, under the warranty, you have to do that for free. You can't charge the consumer. 4, you provide at the consumer's choice, right? At the consumer's choice, either a replacement or a full refund if after a reasonable number of tries you are unable to repair the product. So unlike what we've seen earlier where we've had repair or replacement as being the exclusive remedies, Magnuson Moss says that if you're giving a full warranty, then the consumer has a choice also of full refund in addition to replacement. And then point 5, you do not require consumers to perform any duty as a precondition for receiving service, such as the repair of the product, except notifying you that service is needed unless you can demonstrate that the duty is reasonable. So the idea here is that you're supposed to make it easy for consumers if the product needs to be repaired or replaced to make that happen, right? And if any of these statements isn't true, then you have to designate the warranty as a limited warranty. So let's walk through the rest of this warranty. We see that it's labeled full, so we're going to expect those 5 conditions we just talked about to be the case. So it says here that the seller will promptly supply without charge any missing part, provided a description of the part and model number is given to the seller during the 90-day warranty period. That's probably not an unreasonable expectation on the consumer to give a description of the part and the model number of the product. Seller will promptly repair or replace without charge any defective part, provided the part is returned within the 90-day period, which begins on the date of purchase. Now, it doesn't specifically say here that you could get a refund if they attempted to repair or replace and that was unsuccessful, But because this is labeled a full warranty, that is something that consumers could conceivably ask for. Continuing with our discussion of the swing set warranty, we also want to look for language relating to UCC 2316, and we see this standard conspicuous language around warranty disclaimers. It has the language about merchantability, fitness for a particular purpose. Now, the issue here, as we were discussing in the context of a full warranty, is that if you are offering a full warranty, you are not supposed to be able to limit the duration of your implied warranties. If you had a limited warranty, you could say, well, this is a limited 90-day warranty, therefore the implied warranties are limited to 90 days. But that's not what the seller is doing here. So this is, it seems, an error in the drafting of this provision. And it means that if you're a consumer who has an issue with this product and you want to bring an implied warranty claim, you probably still could do that. All right, and then finally, let's talk about UCC 2719. And so under UCC 2719, we know that it is allowable to give exclusive remedies. It's allowable to exclude consequential damages, and both of those things are done here in this provision. And also, in a nod to the fact that 2719 says it's prima facie unconscionable to exclude consequential damages for personal injuries, this provision expressly says, except that damages for personal injuries shall not be precluded. So it is very consciously nodding to that language in UCC 2719. One thing that would be useful, particularly if you're dealing with a consumer who wants to try to bring, for example, an implied warranty claim, arguing that the implied warranty disclaimers are inoperable under Magnuson-Moss, would be the potential privity issue. So one thing that you would want to know is this provision coming from, is this warranty coming from a direct seller or an indirect seller? Because some courts won't allow implied warranties to run to remote sellers. So we would want to know whether this came from the manufacturer or from a retailer or direct seller to have a good understanding of whether there was direct privity here. Let's pick up with a discussion of our case for today, the Ishmael versus Goodman Toyota case. And what I really want us to look for as we're talking about this case is what legal authority are the plaintiff buyer and the defendant seller relying on as they make their legal arguments in this case? Are they leaning to the commercial code, or are they leaning to Magnuson-Moss? And which one is more favorable to each party? So in this case, we have our plaintiff buyer who bought a used Ford Tempo, traded in his other vehicle from Goodman Toyota. And along with the purchase of the used car, the plaintiff buyer also purchased a 2-year or 24-month, 24,000 mile service agreement on the vehicle. And also, he claims that amongst other things, he received the salesman's assurance of repair on the vehicle. and that the vehicle service agreement was why he purchased the vehicle, because he thought that it would be repaired. It ends up going through numerous repairs. Eventually, it appears that the defendant seller told the plaintiff that, quote, the car could not be repaired and the problems that he was experiencing with the car were normally experienced with used 4-cylinder cars. So at some point, the defendant, it appears, stops attempting to repair the car. Eventually, the plaintiff moves on, tries to get other people to repair the car, is unable to do that, but wisely continues to make payments on the car. The case goes to trial. The trial court, seeming to rely on the UCC, said that the car was purchased as is and rules for the defendant. So it denies any relief to the plaintiff and concluded essentially that the defendant's reasoning was correct. So on appeal, the plaintiff here, the buyer, is contending that the conclusions of law at the trial court were incorrect. Does the as-is clause serve as a waiver of the warranty of merchantability? And on a facial analysis, it might seem like it should. We know under the UCC, we've discussed that as-is provisions for used goods are really common. So does that mean that the implied warranty of merchantability, and again, we identify what warranty we'd want to be dealing with here, is that disclaimed effectively? Or, as the plaintiff would argue, if Magnuson Moss applies, can you disclaim the implied warranty of merchantability? Lower court, as we said, applies the UCC, but the appellate court applies Magnuson Moss. So it asks questions like, is the car a consumer product? Yes. The big question here is, was there a writing that would bring in implied warranties? And the court looks at the agreement in total, so both the purchase agreement but also this vehicle services agreement. So while the purchase agreement had this as-is clause, the buyer also at the same time purchased a service contract along with the car. I recall the 24-month, 24,000-mile service agreement. And so Section 2308A of Magnuson Moss, that talks about restrictions on disclaimers or modifications, says that a supplier cannot disclaim implied warranties to the consumer, jumping down to point 2, if at the time of sale or within 90 days thereafter, such supplier enters into a service contract with the consumer which applies to such consumer product. The court then goes on to say, well, what is a service contract under Magnuson Moss? And it says a contract in writing to perform over a fixed period of time, 24 months, or for a specified duration, or 24,000 miles, services relating to the maintenance or repair or both of a consumer product. Right? So now we have a writing that qualifies under Magnuson Moss. And because of that, the court really takes issue with the conclusions of law that the lower court gave and reverses and remands for a new trial on damages. So in the trial, the plaintiff isn't even going to have to prove that the warranty existed or that it was violated. right? They're going straight to a trial on the damages because, as the court says here, plaintiff conclusively established his entitlement to relief. The only issue remaining to be resolved is the amount of damages to which the plaintiff is entitled. So this case is a really nice, clear illustration of the way in which being able to bring a Magnuson-Moss claim as a consumer can help overcome the warranty disclaimers, particularly these disclaimers of implied warranties that are allowable under the UCC. Let's finish up by looking at some of the distinctions between full warranties under Magnuson-Moss, so warranties that are designated as full, and limited warranties under Magnuson-Moss, so those that have the limited designation at the top. So our first question is it possible to completely disclaim implied warranties? And the answer under either is no. Under a full warranty, you're really not supposed to be able to disclaim or limit the duration of the implied warranties. That's sort of part of what you get with a full warranty, is the implied warranties. The limited warranty, you can limit the period for which you could bring implied warranty claims. 90 days, 1 year limited warranty. After that, theoretically, they can be disclaimed or inoperable, but during that limited warranty period, you were supposed to get implied warranties. So that deals with those first two rows of our chart. Then let's talk about remedies. Can you have an exclusive remedy of repair or replacement? And we know for full warranties, the answer to that is no, because one of the things that the consumer has the option of requesting is a full refund if repair or replacement proves ineffective. Now, under a limited warranty, you can limit to repair or replacement. So you could have a limited warranty where a refund to the consumer is not an option. And then finally, this question of, can you exclude consequential damages? And effectively the answer is yes. Under full warranties, you can exclude consequential damages so long as that exclusion is conspicuous. And the limited warranty provisions in Magnuson-Moss are silent. So it doesn't say, for instance, that it has to be conspicuous, but why tempt the court to take issue with your provision? So if you're going to exclude consequential damages, do it in a conspicuous manner. And so this is a review of what I have just talked about here on this next slide. Is, can you completely disclaim implied warranties? No. Under limited warranties, you can limit their duration. Full warranty, part of what you get with that is a refund. Right? So repair or replacement as the exclusive remedy won't work. Refund still has to be in the mix. But under limited warranty, you can have exclusive remedies of repair or replacement. And then finally, you can exclude consequential damages. Of course, as we started talking about in this lecture, you do want to be thinking about how UCC 2719 interacts with this, because we know that you can't exclude damages for personal injuries, and we are dealing with consumer products with Magnuson-Moss. So you'll want to be cognizant, what is the nature of the harm that a party is seeking damages for? If it's personal injuries, even if there is an exclusion of consequential damages under Magnuson-Moss, you may still have the potential to argue that something is prima facie unconscionable if it serves to exclude consequential damages for personal injuries. We'll talk about the discussion problems for Assignment 13 during our in-person call. Thanks.